Hello, everyone. Welcome to Court with Krissy and Linda. It's apparent the cat does not have this defendant's tongue. But don't worry, there comes a point when he is done talking. I hope you like it. Court with Krissy and Linda is meow in session.
First case the court is going to call is State of North Dakota versus Nicholas Lee Sanchez, 02-2025 CR97. Present in court for the state, Attorney Trent Jackson. The defendant, Mr. Sanchez, appears by reliable electronic means from the Department of Corrections and Rehabilitation. Mr. Sanchez, your attorney, Ms. Chisholm, contacted the clerk's office shortly before court, indicating that she has another hearing scheduled essentially for the same time, and she is unavailable until after that hearing. Ultimately, today is a scheduled. Oh, she's just walking in the room here. So Ms. Chisholm is walking in the room. Ms. Chisholm, I've called Mr. Sanchez's case because he is at the DOCR, and we need to take that one up first.
I apologize, Your Honor. I thought they had relayed to you that I had an administrative hearing at 1:15.
They did, but ultimately I still have to take this one up first because it's the DOCR hearing, and they ultimately will cut off Mr. Sanchez's access regardless of what I order. So, Mr. Sanchez, were you present in court when the rights were read to you?
Yes, I was, Your Honor.
You understand your rights?
Yes.
We're here for a dispositional conference. In your case, you have filed essentially a mandatory disposition of detainers act notice, which to me is treated much similar to a speedy trial request. And so
Yes,
today,
I also had put in a form for a new attorney. I'm requesting new counsel on this case. I would like to represent myself today, if possible.
well, I haven't seen any request for substitute counsel, and Ms. Chisholm has not filed a motion to withdraw as counsel.
Well, I sent it in about a week ago, so it'll be coming shortly in the mail.
Well, for today's purposes, Ms. Chisholm is still your counsel, but
Okay, well, I would like to speak on my behalf, is what I'm saying.
I'm going to give you an opportunity, so just hold on. The options today are setting today's case for a jury trial, a bench trial, a continuance, to change your plea from not guilty to guilty today, or to seek to schedule a change of plea for a later date. Ms. Chisholm, what does your client want to do?
I think for today's purposes, in light of what Mr. Sanchez is indicating, that the court should either continue this or set it for a jury trial. And then if Mr. Sanchez and his new counsel decide they would like something in the alternative, they could certainly notify the state. I don't think they would have an objection.
No, I would still like a fast.
So stop talking.
Is what I'm saying.
I'm going to give you an opportunity to talk, but wait for your turn, okay? So, Ms. Chisholm, continuance or set it for a jury trial?
Yes, Your Honor.
All right. What's the state's position on simply setting it for a jury trial?
Your Honor, that's fine. The state is fine with either option. Presumably, if he does get different counsel, I would imagine that a continuance would be coming anyway. So I'll leave it up to Your Honor, especially since you treat these matters like a speedy trial request. Perhaps setting it for trial would make sense. But again, if he's going to be requesting new counsel, I can see where a continuance would be coming down the line.
How long will it take to try?
Your Honor, I would imagine at least 2 days.
Give me just a minute here.
I would also like to address bond, Your Honor.
Just hold on, sir. I'm going to give you an opportunity to speak. Just give me a minute. All right. Mr. Sanchez, with respect to your request for a trial or a continuance, what is your position on how we move forward today?
I would still like the case to be set for trial within a 90-day period. And that should still give my new counsel time to get up to par for me to get my discovery, something that I've never obtained, This case is almost a year and a half, almost 2 years old. I'll be filing a motion for dismissal and we'll see how that goes, but I would like to address bond as well today. I've been incarcerated for about 10 months, and since I've
Hold on.
been incarcerated
Stop.
and
Sir.
to treatment,
Stop talking, please. Let me address one thing at a time. First issue is setting the matter for trial. The state has indicated that it'll take 2 days for trial. The Mandatory Disposition of Detainers Act requires the court to hold the jury trial within 90 days of the date that the request has been certified. The request was certified March 13, 2026. The court sets the trial to begin May 4, 2026 at 8:30 a.m. as jury selection. I'm sorry, 8:30 a.m. will be pretrial with jury selection to begin at 9 a.m. The court sets the trial for 2 days, May 4 and May 5. May 5 will start at 9 a.m. I will ask the state to prepare an order for transport for that trial date. So Mr. Sanchez will be local at the time that that trial occurs. Understood, Mr. Jackson?
Yes, Your Honor.
All right. Now, Mr. Sanchez, you can go ahead and tell me what you want me to know about bail. I will advise you and tell you that these are recorded proceedings. Anything you say can and will be used against you. You have the absolute right to remain silent. I do want you to know that if you choose to remain silent, that silence will not be used against you in any way whatsoever. If you choose to make a statement, sir, I would advise you to limit your comments to those related to bail. Because again, anything you say can and will be used against you. The state can obtain a transcript of today's proceedings and can use those statements in later court hearings. Do you understand that, sir?
yes, Your Honor.
What is your thoughts, or what are your thoughts on bail?
So I've been in and out of incarceration and then to treatment within the past 12 months. I've been incarcerated this time almost 10 months. Since the court date that I did not show up to, I was either in treatment or incarcerated from Burleigh County to treatment to the North Dakota DOC. And I had previously posted a cash bond in this case, and I would like to possibly either have my bond reinstated or to have my bond reinstated, please, is what I'm asking. I mean, this case is, like I said, almost 2 years old, and it's affecting me and my classification with me being here at the North Dakota State Penitentiary. And I mean, we can all see how long I've been incarcerated. I had informed my attorney at the time. She did not want to help me. That's part of the reason why I had asked for new representation. And yes.
So there are a couple of issues to unpack there. The first, in this case, there was a bond order entered on April 28, 2025. That bond at that time was set at $1,500 post 10% plus additional requirements, including the 24/7 sobriety program and other conditions. Judge Schachman had signed that bond order. Thereafter, there was a 24/7 no-show on July 15, 2025. A bench warrant was issued on August 12, 2025. At that time,
I was in treatment, Your Honor. I had the treatment facility.
this is where I'm talking. Okay, so there was a bench warrant that was issued at that time for non-appearance in court. The defendant failed to appear at a dispositional conference. He was not excused from his appearance at that dispositional conference.
I had informed my faulty.
Sir, you need to stop interrupting me.
I had
Please.
informed my faulty return.
Please stop talking. So a bench warrant was issued, an appearance was required. At the same time, the state requested the court to forfeit the bond. On August 13, 2025, there was a notice of bond forfeiture that was filed.
What about for the treatment
Sir,
that
again,
was filed?
please stop
Can we
interrupting.
do that?
Please, sir. The court forfeited bond. And that was done back on August 12, 2025. And that order was filed into the record on August 13, 2025, record index 32. Thereafter, that warrant has been outstanding. The court received notice and request of disposition of detainer. The notice from the Department of Corrections indicates that you received a 4-year, 5-month, and 17-day commitment, and that you are eligible for parole review. Not that you're going to be paroled, but you're eligible for parole review starting on March 12, 2026, and that your good time release date is June 14, 2029. The maximum expiration date under your present sentence is March 11, 2030. All right, so circling back to the issue of the bond forfeiture. Rule 46 of the North Dakota Rules of Criminal Procedure addresses bond forfeiture. Rule 46 states, in pertinent part, in just a moment here, setting aside bail forfeiture, Rule 46 F2B. Any motion for a bail forfeiture to be set aside must be filed with the clerk of court within 90 days of the date of the order of forfeiture. Here, we are well beyond that 90-day bail forfeiture, and so I don't have the authority under the rule to undo or set aside the order of forfeiture, which was entered August 12, 2025. So your request for the court to reinstate that bail and not forfeit it is denied because I don't have the authority to do so under the rule.
So what are you telling me? I have to file a motion for ineffective counsel to prove otherwise?
Well, you can do whatever you think is appropriate, but I'm telling you, I can't undo the order of forfeiture because the rule doesn't let me do that now.
Well, then can we address bond then, Your Honor?
Well, so the warrant is outstanding, and on top of that, sir, what that document tells me when this is a mandatory disposition of detainers act case is I could set your bail at 0 and you're not going anywhere.
Well, then set it to what you want to set it at, but can we address bond?
So I just did.
Simple as that. When's my, okay, that's it. Court date open.
So anything else for the state?
No, Your Honor.
Anything else, Ms. Chisholm?
No, Your Honor, thank you.
Mr. Sanchez apparently disconnected before we were done with the hearing. And so obviously he's done talking. This matter is adjourned.